The representatives referred to in Clause 1A of this article shall be elected on the basis of universal adult suffrage and by secret ballot. 4. The Parliament shall by law prescribe the procedure for elections of representatives referred to in Clause 1B and C of this article. Functions of Parliament. 1. Subject to the provisions of this Constitution, Parliament shall have the power to make laws on any matter for the peace, order, development, and good governance of Uganda. 2. Except as provided in this Constitution, no person or body other than Parliament shall have power to make provisions having the force of law in Uganda except under authority conferred by an Act of Parliament. 3. Parliament shall protect this Constitution and promote the democratic governance of Uganda. 80. Qualifications and disqualifications of members of Parliament. 1. A person is qualified to be a member of Parliament if that person A is a citizen of Uganda, B is a registered voter, and C has completed a minimum formal education of advanced level standard or its equivalent. 2. A person is not qualified for elections as member of Parliament if that person is of unsound mind. B is holding or acting in an office the functions of which involve a responsibility for or in connection with the conduct of an election. C. A tradition or a cultural leader as defined in Article 246 6 of this Constitution. D. Has been adjourned or otherwise declared bankrupt under any law in force in Uganda, has not been recognized, discharged, or C. Is under a sentence of death or a sentence of imprisonment exceeding 9 months imposed by any content court without the option of a fine. C. A person elected to Parliament when he or she is a member of a local government council or holds a public office shall resign the office before assuming the office of Member of Parliament. 81. Elections of Members of Parliament. 1. A general election of Members of Parliament shall be held within 30 days before the expiration of the term of Parliament. 2. Wherever a vacancy exists in Parliament, the Clerk to Parliament shall notify the Electoral Commission in writing within 10 days after the vacancy has occurred, and a by-election shall be held within 60 days after the vacancy has occurred. 3. Notwithstanding Clause 2 of this article, a by-election shall not be held within 6 months before the holding of a general election of Parliament. 4. Every person elected to Parliament shall take and subscribe the oath of allegiance and the oath of Member of Parliament specified in the 4th schedule to this Constitution. 5. Except for the purposes of taking the oath referred to in Clause 4 of this article, no person shall sit or vote in Parliament before taking and subscribing to the oaths. 82. Speaker and Deputy Speaker of Parliament. 1. There shall be a Speaker and a Deputy Speaker of Parliament. 2. The Speaker and Deputy Speaker shall be elected by Members of Parliament from among their number. 3. A person shall not be qualified to be elected a Speaker or Deputy Speaker if he or she is a Vice President or a Minister. 4. Subject to Article 81(4) of this Constitution, no business shall be transacted in Parliament other than an election to the office of Speaker at any time that office is vacant. 5. The Chief Justice or a judge designated by the Chief Justice shall preside at an election of a Speaker, and the Speaker shall preside at an election of the Deputy Speaker. 6. An election to the office of Deputy Speaker shall be held at the first sitting of Parliament after the office becomes vacant. 7. The Deputy Speaker, the Speaker or the Deputy Speaker shall vacate his or her office, A, if he or she is appointed to any public office, B, if he or she becomes a minister, C, if he or she resigns his or her office by writing signed by him or her, addressed to the clerk to the Parliament, D, if he or she ceases to be a member of Parliament, or E, if he or she is removed by resolution of Parliament supported by not less than 2/3 of all members of Parliament. 8. The Speaker and the Deputy Speaker shall receive such salaries, allowances, and gratuities as may be prescribed by Parliament. 9. The salaries, allowances, and gratitudes. Gratitudes of the Speaker and Deputy Speaker shall be charged on the consolidated fund. 10. The Speaker and Deputy Speaker shall each, before assuming the duties of office, take and subscribe the oath of Speaker or Deputy Speaker specified in the fourth schedule of this Constitution. 8. Tenure of office of members of Parliament. 1. A member of Parliament shall vacate his or her seat in Parliament, A, if he or she resigns his or her office in writing signed by him or her and addressed to the Speaker, B, if such circumstances arise that if that person were not a member of Parliament would cause that person to be disqualified for election as a member of Parliament under Article 80 of this Constitution. C. Subject to the provisions of this Constitution upon dissolution of Parliament. D. If that person is absent from 15 sittings of Parliament without permission in writing of the Speaker during any period when Parliament is continuously meeting and is unable to offer satisfactory explanation to the relevant parliamentary committee for his or her absence. E. If that person is found guilty by the appropriate tribunal of violation of the Leadership Code of Conduct and the punishment imposed is or includes the vacation of the office of a member of Parliament. F. If recalled by the elector in his or her constituency in accordance with this Constitution. G. If that person leaves the political party for which he or she stood as a candidate for election to Parliament to join another party or to remain in Parliament as an independent member. H. If having been elected to Parliament as an independent candidate, that person joins a political party. I. If that person is appointed a public officer. 2. Notwithstanding clause 1G and H of this article, membership of a coalition government of which his or her original political party forms part shall not affect the status of any member of Parliament. 3. The provisions of clause 1G and H and 2 of this article shall only apply during a period when the multi-party system of government is in operation. 84. Right of recall. 1. Subject to the provisions of this article, the electorate of any constituency and of any interest group referred to in Article 78 of this Constitution have the right to recall their member of Parliament before the expiry of the term of Parliament. 2. A member of Parliament may be recalled from the office on any of the following grounds. A. Physical or mental incapacity rendering that member incapable of performing the functions of the office. 2. B. Misconduct or misbehavior likely to bring hatred, ridicule, contempt, or disrepute to the office. Or C. Persistent deserting of the electorate without reasonable cause. 3. Recall of a member of parliament shall be initiated by a petition in writing, setting out the grounds relied on and signed by at least 2/3 of the registered voters of the constituency or of the interest group referred to in clause 1 of this article, and shall be delivered to the speaker. 4. On the receipt of this petition referred to in clause 3 of this article, the speaker shall within 7 days require the electoral commission to conduct a public inquiry into the matters alleged in the petition, and the electoral commission shall expeditiously conduct the necessary inquiry and report its findings to the speaker. 5. The speaker shall declare the seat vacant if the electoral commission reports that it is satisfied from the inquiry with the genuineness of the petition, or B. Declare immediately that the petition was unjustified if the commission reports that it is not satisfied with the genuineness of the petition. 6. Subject to the provisions of clauses 2, 3, 4, and 5 of this article, Parliament shall by law prescribe the procedure to be followed for the recall of a member of Parliament. 85. Emoluments of members of Parliament. 1. A member of Parliament shall be paid such emolument and shall gratuity and shall be provided with such faculties as may be determined by Parliament. 2. A member of Parliament shall not hold any office of profit or embezzlement likely to compromise his or her office. 86. Determination of questions of membership. 1. The High Court shall have jurisdiction to hear and determine any question whether A. A person has been validly elected as Member of Parliament, or the seat of a Member of Parliament has been vacant, or B. A person has validly elected as Speaker or Deputy Speaker, or having been elected has vacated that office. 2. A person aggravated by the determination of the High Court under this article may appeal to the Court of Appeal. 3. Parliament shall by law make provision with respect to A. Persons eligible to apply to High Court for determination of any question under this article, and B. The circumstances and manner in which and the conditions upon which any such application may be made. 87. Clerk to Parliament and other staff. There shall be a public officer designated Clerk to Parliament appointed by the President in consultation with the Public Service Commission and such other members of staff as may be necessary for the efficient discharge of the functions of Parliament. Procedure of Parliament. 88. Quorum of Parliament. 1. The quorum of Parliament shall be 1/3 of all members of Parliament entitled to vote. 2. The quorum prescribed by clause 1 of this article shall only be required at a time when Parliament is voting on any question. 3. Rules of procedure of Parliament shall prescribe the quorum of Parliament for the conduct of business of Parliament other than for voting. 89. Voting in Parliament. 1. Except otherwise prescribed by this Constitution or any other law consistent with this Constitution, any question proposed for decision of Parliament shall be determined by a majority of votes of the members present and voting in a manner prescribed by rules of procedure made by Parliament under Article 94 of this Constitution. 2. The person presiding in Parliament shall have neither an original nor a casting vote, and if on any question before Parliament the votes are equally divided, the motion shall be lost. 90. Committees of Parliament. 1. Parliament shall appoint standing committees and other committees necessary for the efficient discharge of its functions. 2. The committees of Parliament shall include seasonal committees and a committee of the whole House. 3. Rules of procedure of Parliament shall prescribe the composition and functions of committees of Parliament. 4. In the exercise of their functions under this article, committees of Parliament A. may call any minister or any person holding public office and private individuals to submit memoranda or appear before them to give evidence. B. may co-opt any member of Parliament or employ qualified persons to assist them in the discharge of their functions. C. shall have the powers of High Court for 1. enforcing the attendance of witnesses and examining them on oath, affirmation or otherwise. 2. compiling the production of documents, and 3. issuing a commission or request to examine witnesses abroad. 91. Exercise of legislative powers. 1. Subject to the provisions of this Constitution, the power of Parliament to make laws shall be exercised through bills passed by Parliament and assented to by the President. 2. A bill passed by Parliament shall, as soon as possible, be presented to President for assent. 3. The President shall, within 30 days after a bill is presented to him or her, A. assent to the bill, B. return the bill to Parliament with a request that the bill or a particular provision of it be reconsidered by Parliament, or C. notify the Speaker in writing that he or she refuses to assent to the bill. 4. Where a bill has been returned to Parliament under Clause 3b of this article, Parliament shall reconsider it, and if passed again, it shall be presented for a second time to President for assent. 5. Where the President returns the bill twice under Clause 3b of this article, and the bill is passed for the third time with the support of at least 2/3 of members of Parliament, the Speaker shall cause a copy of the bill to be laid before Parliament, and the bill shall become law without the assent of President. 6. Where the President A. refuses to assent to a bill under Clause 3c of this article, Parliament may reconsider the bill, and if passed, the bill shall be presented to Parliament to President for assent. B. refuses to assent to a bill which has been reconsidered and passed under paragraph A or clause 4 of this article. The Speaker shall, upon the refusal, if the bill was so passed with the support of at least 2/3 of all members of Parliament, cause a copy of the bill to be laid before Parliament, and the bill shall become law without the assent of the President. Where the President fails to do any of the acts specified in Clause 3 of this article within the period prescribed in that clause, the President shall be taken to have assented to the bill, and at the expiration of that period, the Speaker shall cause a copy of the bill to be laid before Parliament, and the bill shall become law without the assent of the President. 8. A bill passed by Parliament and assented to by the President, or which has otherwise become law under this article, shall be an article and shall be an act of Parliament and shall be published in the Gazette. 92. Restriction on retrospective legislation. Parliament shall not pass any law to alter the decision or judgment of any court as between the parties to the decision or judgment. 93. Restriction on financial matters. Parliament shall not, unless the bill or the motion is introduced on behalf of the government, A. proceed upon a bill including an amendment bill that makes provision for any of the following. 1. The imposition of taxation or the alteration of taxation otherwise than by reduction. 2. The imposition of a charge on the consolidated fund or other public funds of Uganda, or the alteration of any such charge otherwise than by reduction. 3. The payment, issue, or withdraw from the consolidated fund or other public fund of Uganda of any monies not charged on that fund or any increase in the amount of that payment, issue or withdraw, or 4. The composition or remission of any debt due to the government of Uganda, or B. Proceed upon a motion including an amendment to a motion, the effect of which would be to make provision for any of the purposes specified in paragraph A of this article. 94. Rules of procedure in Parliament. 1. Subject to the provisions of this Constitution, Parliament may make rules to regulate its own procedure, including the procedure of its own committees. 2. Parliament may act notwithstanding a vacancy in its membership. 3. The presence or the participation of a person not entitled to the present or to participate in the proceedings of Parliament shall not by itself invalidate those proceedings. 4. The rules of procedure of Parliament shall include the following provisions. A. The Speaker shall determine the order of business in Parliament and shall give priority to government business. B. A member of Parliament has the right to move a private member's bill. C. The member moving the private member's bill shall be offered reasonable assistance by the Department of Government whose area of operation is affected by the bill. And D. The office of the Attorney General shall afford the member moving the private bill professional assistance in the drafting of the bill. 95. Sessions of Parliament. 1. Where a new Parliament is elected, the President shall, by proclamation, appoint the place and the date not beyond 7 days after the expiration of the term of Parliament, or of the extended period as the case may be for the first sitting of the new Parliament. 2. A session of Parliament shall be held at such place within Uganda and shall commence at such time as the Speaker may, by proclamation, appoint proclamation appoint. 3. The Speaker, after consultation with the President, prorogue Parliament by proclamation. 4. A session of Parliament shall be held at least once a year, but the period between one session and the next following session shall be less than 12 months. 5. Notwithstanding any other provision of this article, at least 1/3 of all members of Parliament may, in writing, signed by them, request a meeting of Parliament, and the Speaker shall summon Parliament to meet within 21 days after receipt of this request. 96. Dissolution of Parliament. Parliament shall stand dissolved upon the expiration of its term as prescribed by Article 77 of its Constitution General. 97. Parliamentary immunities and privileges. 1. The Speaker, the Deputy Speaker, members of Parliament, and any other person participating or assisting in or acting in connection with or reporting the proceedings of Parliament or any of its committees shall be entitled to such immunities and privileges as Parliament shall by law prescribe. 2. Notwithstanding Article 41 of this Constitution, no member or officer of Parliament, and no person employed to take minutes of evidence before Parliament or any committee of Parliament shall give evidence elsewhere in respect of the contents of such minutes of evidence or the contents of any document laid before Parliament or any such committee as the case may be, or in respect of any proceedings or examination held before Parliament or such committee without the special leave of Parliament first obtained. Three, the special leave referred to in clause 2 of this article may, during a recess or adjournment of Parliament, be given by the Speaker or any, in the absence or incapacity of the Speaker, during a dissolution of Parliament by Clerk to Parliament. Chapter 7, the Executive, the President. 98. The President of Uganda. 1. There shall be a President of Uganda who shall be the head of state, head of government, and commander-in-chief of the Uganda People's Defense Forces and the fountain of honor. 2. The President shall take precedence over all persons in Uganda, and in descending order, the Vice President, the Speaker, and the Chief Justice shall take the precedence over all persons in Uganda. 3. Before assuming the duties of the office of President, a person elected President shall take and subscribe the oath of allegiance and the presidential oath specified in the fourth schedule of this Constitution. While holding office, the President may not be liable to proceedings in any court. 5. Civil or criminal proceedings may be instituted against a person after ceasing to be President, in respect of anything done or omitted to be done in his or her personal capacity before or during the term of office of that person, and any period of limitation in respect of any such proceedings shall not be taken to run during the period while that person was President. 99. Executive Authority of Uganda. The executive authority of Uganda is vested in the President and shall be exercised in accordance with its constitution and the laws of Uganda. 2. The President shall execute and maintain this constitution and all laws made under or contained in force by this constitution. 3. It shall be the duty of the President to abide by, uphold, and safeguard its constitution and the laws of Uganda, and to promote the welfare of citizens and protect the territorial integrity of Uganda. 4. Subject to the provisions of this constitution, functions conferred on the President by clause 1 of this article may be exercised by the President either directly or through officers subordinate to the President. 5. A statutory instrument or other instrument issued by the President or any person authorized by the President may be authenticated by the signature of a minister, and the validity of any instrument so authenticated shall not be called in question on the ground that it is not made, issued, or executed by the President. 100. Notification of the absence of the President from Uganda. The President shall, whenever leaving Uganda, notify in writing in writing the Vice President, the Speaker, and the Chief Justice. 101. Presidential addresses. 1. The President shall, at the beginning of each session of Parliament, deliver to Parliament an address on the state of nation. 2. President may also, in consultation with the Speaker, address Parliament from time to time on any matter of national importance. 102. Qualifications of the President. A person is not qualified for election as President unless that person is A citizen of Uganda by birth, B, not less than 35 years and not more than 75 years of age, and a person qualified to be a member of Parliament. 103. Election of the President. 1. The election of President shall be by universal adult suffrage through a secret ballot. 2. A person shall not be a candidate in presidential elections unless A, that person submits the Electoral Commission on or before the day appointed as nomination day in relation to the election, or a document which is signed by that person nominating him or her as a candidate, and B, the nomination is supported by 100 voters in each of at least 2/3 of all districts in Uganda. 3. The election of the Parliament. The election of the President shall be held during the first 30 days of the last 90 days before the expiration of the term of the President, except in the case of A, the first election under this Constitution, B, an election held under Article 1046 of this Constitution, C, an election held under Article 1092 of this Constitution, and D, an election necessitated by the fact that a normal presidential election could not be held as a result of the existence of a state of war or a state of emergency, in which case the election shall be held within specific period as Parliament may by law prescribe. 4. A candidate shall not be declared elected as President unless the number of votes cast in favor of that person at the presidential election is more than 50% of valid votes cast at that election. 5. Where at a presidential election no candidate obtains the percentage of votes specified in clause 4 of this article, a second election shall be held within 30 days after the declaration of the results, in which election the two candidates who obtain the highest number of votes shall be the only candidates. 6. The candidate who obtains the highest number of votes in an election under clause 5 of this article shall be declared elected President. 7. The Electoral Commission shall sustain, publish, and declare in writing under its seal the results of the presidential election within 48 hours from the closing of polling. 8. A person elected president during the term of a president shall assume office within 24 hours after the expiration of the term of the predecessor, and in any other case within 24 hours after being declared elected as president. 9. Subject to the provisions of this Constitution, Parliament shall by law prescribe the procedure of the election and assumption of office by a president. 104. Challenging a presidential election. 1. Subject to the provisions of this article, any aggregated candidate may petition the Supreme Court for an order that a candidate declared by the Electoral Commission elected as president was not validly elected. 2. A petition under clause 1 of this article shall be lodged in the Supreme Court registry within 10 days after the declaration of the election results. 3. The Supreme Court shall inquire into and determine the petition expended expeditiously and shall declare its findings not later than 30 days from the date the petition is filed. 4. Where no petition is filed within the time prescribed under Clause 2 of this article, or where a petition being filed is dismissed by the Supreme Court, the candidate elected shall conclusively be taken to have been duly elected as president. 5. After due inquiry under Clause 3 of this article, the Supreme Court may A. dismiss the petition, B. declare which candidate was validly elected, or C. annul the election. 6. Where an election is annulled, a fresh election shall be held within 20 days from the date of the annulment. 7. If after a fresh election held under Clause 6 of this article, there is another petition which succeeds, then the presidential election shall be postponed, and upon the expiry of the term of the incumbent president, the Speaker shall perform the duties of the office of president until a new president is elected and assumes office. 8. For the purposes of this article, Article 98(4) of this Constitution shall not apply. 9. Parliament shall make such laws as may be necessary for the purposes of this article, including laws for grounds of annulment and rules of procedure. 105. Tenure of office of a president. 1. A person elected president under this Constitution shall, subject to Clause 3 of this article, hold office for a term of 5 years. 2. A person shall not be elected under this Constitution to hold office as president for more than 2 terms as prescribed by this article. 3. The office of president shall become vacant, A. on the expiration of the period specified in this article, or B. if the incumbent dies or resigns or ceases to hold office under Article 107 of this Constitution. 4. The President may, by writing signed by him or her and addressed to the Chief Justice, resign from office as President. 5. The resignation of the President shall take effect when it's received by the Chief Justice. 6. The Chief Justice shall immediately, upon receiving the resignation of the President under this article, notify the Vice President, the Speaker, and the Electoral Commission of the resignation. 106. Terms and conditions of service of the President. 1. The President shall be paid a salary and allowances and afforded such other benefits as Parliament shall by law provide. 2. Parliament shall by law make provision for the grant of benefits for a president who ceases to hold office otherwise than by being removed under Article 107, 1A or B of this Constitution. 3. The salary, allowances, and other benefits granted to a president under this article shall be charged on the consolidated fund. 4. The president is exempted from direct personal taxation on allowances and other benefits except on the official salary. 5. The president shall not hold any other public office other than those conferred by this Constitution, or any office of profit or emolument likely to compromise the office of President. 6. The salary, allowances, and benefits granted to the President under this article shall not be varied to the disadvantage of the President while he or she holds office. 7. The retirement benefits granted to a president under this article shall not be varied to the disadvantage of the president. 107. Removal of the president. 1. The president may be removed from office in accordance with this article or on any of the following grounds. A. Abuse of office or willful violation of the oath of allegiance and the presidential oath or any provision of this constitution. B. Misconduct or misbehavior. 1. That he or she has conducted himself or herself in a manner which brings or is likely to bring the office of president into hatred, ridicule, contempt, or disrepute, or that he or she has dishonestly done any act or omission which is prejudicial or inimical, prejudicial, okay, which is prejudicial or inimical to the economy or security of Uganda, or physical or mental incapacity, namely that he or she is incapable of performing the functions of his or office by reason of physical or mental incapacity. 2. For the purpose of removal of the president under clause 1A or B of this article, a notice in writing signed not less than 1/3 of all the members of parliament shall be submitted to Speaker, stating that they intend to remove a motion for a resolution in parliament for the removal of the president on the charge that the president has 1. Willfully abused his or her office or willfully violated the oath of allegiance and the presidential oath or any other provision of this constitution in terms of clause 1A of this article, or 2. Misconducted himself or herself or misbehaved in terms of clause 1B of this article, and B. Setting out the particulars of the charge supported by the necessary documents on which it is claimed that the conduct of the president being investigated for the purposes of his or her removal. The Speaker shall, within 24 hours after receipt of the notice referred to in clause 2 of this article, cause a copy to be transmitted to the President and the Chief Justice. 4. The Chief Justice shall, within 7 days after receipt of the notice transmitted under clause 3 of this article, constitute a tribunal comprising three justices of the Supreme Court to investigate the allegation in the notice and to report its findings to Parliament, stating whether or not there is a prima facie case for the removal of the President. 5. The President is entitled to appear at the proceedings of the tribunal and to be represented there by a lawyer or other expert, a person of his or her choice. 6. If the tribunal determines that there is a prima facie case for the removal of the president under clause 1A or B of this article, then if Parliament passes the resolution supported by the votes of not less than 2/3 of all members of Parliament, the President shall cease to hold office. 7. For purposes of removal of President on grounds of physical or mental incapacity under clause 1C of this article, there shall be submitted to Parliament a notice in writing signed by not less than 1/3 of all the members of Parliament, A, stating that they intend to remove a motion for a resolution in Parliament for the removal of the President from office on grounds of physical or mental incapacity, and B, giving particulars of the alleged incapacity. 8. 8. The Speaker shall, within 24 hours after receipt of a notice under Clause 7 of this article, cause a copy to be transmitted to the President and the Chief Justice. The Chief Justice shall, within 7 days after receipt of the notice transmitted under Clause 8 of this article and in consultation with the professional head of the medical services in Uganda, constitute a medical board comprising 5 qualified and eminent medical specialists to examine the President in respect of the alleged incapacity and to report its findings to the Parliament. 10. The Chief Justice shall within 24 hours after constituting the medical board inform the President accordingly, and the President shall submit himself or herself to the medical board for examination within 7 days. 11. If the medical board determines that the President is by reason of physical or mental capacity unable to perform the functions of the office of President, and Parliament passes the resolution for the removal of the President supported by the votes of not less than 2/3 of all the members of Parliament, the President shall cease to hold office. If the medical board, after the expiration of the period of 7 days referred to in Clause 10 of this article, reports that the President has failed or refused to submit to the medical board in accordance with that clause, and Parliament passes the resolution for the removal of the President, supported by the votes of not less than 2/3 of all members of Parliament, the President shall cease to hold office. 13. The motion for a resolution for the removal of President shall be removed in Parliament within 14 days after the receipt by the Speaker of the report of tribunal or the medical board. 14. The President is entitled to appear in person and be heard and to be assisted or represented by a lawyer or other expert or person of his or her choice during the proceedings of Parliament relating to the motion for a resolution under this article. 108. Vice President. 1. There shall be a Vice President of Uganda. 2. The President shall, with the approval of Parliament by a simple majority, appoint a Vice President. 3. The Vice President shall deputes for the President as and when the need arises, and B. Performs such other functions as may be assigned to him or her by the President or as may be conferred on him or her by this Constitution. 4. The qualifications prescribed for the office of President by Article 102 of this Constitution shall apply to the office of Vice President. 5. The office of Vice President shall become vacant if A. The appointment is revoked by President, or B. The incumbent resigns or dies. 6. With the exception of Clause 2 of that article, Article 106 of this Constitution shall, subject to this Constitution, apply to the Vice President. 7. Where the office of Vice President becomes vacant, the President shall, with the approval of Parliament and as soon as possible, but in any case not later than 14 days, appoint a person qualified to hold the office of Vice President. 8. The Vice President shall, before commencing to perform the functions of Vice President, take and subscribe the oath of allegiance and the oath of Vice President specified in the fourth schedule to this Constitution. 109. Absence of the President. 1. If the President dies, resigns, or is removed from office under this Constitution, the Vice President shall assume the office of President until fresh elections are held and the elected President assumes office in accordance with Article 103(8) of this Constitution. Elections for the President under this article shall be held within 6 months after the death, resignation, or removal of the President. 3. No elections shall be held under this article if the residue term of the President is 1 year or less. 4. Whenever the President is for any reason unable to perform the functions of the President, The vice president shall perform those functions until the president is able to again perform those functions. 5. Where the president and the vice president are both unable to perform the functions of the president, the functions of office of the president, the speaker shall perform those functions until the president or the vice president is able to perform those functions, or until a new president assumes office. 6. The vice president shall be The vice president shall, before assuming the duties of the office of president under clause 1 of this article, appoint a person to the office of vice president subject to the approval of parliament. 7. A person appointed under clause 6 of this article shall, before assuming the duties of the office of the vice president, take and subscribe the oath in respect of that office under the article 108.7 of this Constitution. 8. Before assuming the duties of the office of president under clause 5 of this article, the speaker shall take and subscribe the oath specified in relation to that office in the 4th schedule to this Constitution. 9. Whenever the speaker assumes the office of president as a result of the death, resignation, or removal of the president and the vice president under the provisions of Article 104.7 of this Constitution, a presidential election shall be held in accordance with Clause 2 of this article. 110. State of emergency. 1. The president may, in consultation with the cabinet, by proclamation, declare that a state of emergency exists in Uganda or in a part of Uganda if the president is satisfied that circumstances exist in Uganda or in that part of Uganda. A. In which Uganda or that part of it is threatened by war or external aggregation. B. In which the security or the economic life of the country or that part is threatened by internal insurgency or natural disaster, or C. which render necessary the taking of measures which are required for securing the public safety, the defense of Uganda, and the maintenance of public order and supplies and services essential to the life of the community. 2. Subject to the provisions of this article, a state of emergency declared under clause 1 of this article shall remain in existence for not more than 90 days after shall then expire. 3. The president shall cause the proclamation declaring the state of emergency to be laid before Parliament for approval as soon as practicable, and in any case not later than 14 days after it was issued. 4. A state of emergency may be extended by Parliament for a period not exceeding 90 days at a time. 5. The President or Parliament shall, if satisfied that the circumstances for the declaration of the state of emergency have ceased to exist, revoke the proclamation by which the state of emergency was declared. 6. During any period when a state of emergency declared under this article exists, the President shall submit to Parliament at such intervals as Parliament may prescribe regular reports on actions taken by or on behalf of the President for the purposes of the emergency. 7. Subject to the provisions of this Constitution, Parliament shall enact such laws as may be necessary for enabling effective measures to be taken for dealings with any state of emergency that may be declared under this article. 8. Any resolution passed by the Parliament for the purposes of Clause 4 of or 5 of this article shall be supported by the votes of more than one half of all members of parliament. The cabinet. 111. The cabinet. 1. There shall be a cabinet which consists of the president, the vice president, and such numbers of ministers as appear to the president to be the reasonably necessary for the efficient running of the state. 2. The functions of the cabinet shall be determined, formulate and implement the policy of the government, and to perform such other functions as may be conferred by the constitution or in other law. There shall be a secretary to the cabinet who shall be appointed by the president in consultation with the Public Service Commission. 4. The secretary to the cabinet shall have charge of the cabinet office and shall be responsible in accordance with such instructions as may be given to him or her by the president for arranging the business for and keeping the minutes of the cabinet, and for conveying the decisions of cabinet to appropriate person or authority, and perform such other functions as the president may direct. 5. The secretary to the cabinet shall, before assuming the duties of his or her office, take and subscribe the oath of allegiance and the oath of secretary to the cabinet specified in the fourth schedule to this article. 12. 112. Meetings of the cabinet. 1. Cabinet meetings shall be summoned and presided over by the president, and in his or her absence by the vice president, or in the absence of both of them by a minister designated in writing by the president. 12. The cabinet shall regulate the procedure of its meetings. 113. Cabinet ministers. 1. The cabinet ministers shall be appointed by the president with the approval of parliament from among members of parliament or persons qualified to be elected members of parliament. 2. The total number of cabinet ministers shall not exceed 21, except with the approval of parliament. 3. A cabinet minister shall have responsibility for such functions of government as the president may from time to time assign to him or her. 4. A minister shall not hold any office of profit or emolument likely to compromise his or her office. 114. Other ministers. 1. The president may, with the approval of parliament, appoint other ministers to assist cabinet ministers in performance of their functions. 2. Subject to the provisions of this article, Article 113(1) of this Constitution shall apply to the appointment of ministers under Clause 1 of this article. 3. The total number of ministers appointed under this article shall not exceed 21, except with the approval of Parliament. 4. A minister referred to in this article shall have responsibility for such functions of the ministry to which he or she is appointed, as the president may, from time to time, assign to him or her, and in the absence of the cabinet minister in his or her ministry shall perform the functions of the cabinet minister as the president directs. 5. Article 113(4) of this Constitution applies to a minister referred to in Clause 1 of this article. 115. Oath of minister. A minister shall, before assuming the duties of office, take and subscribe the oath of allegiance and the oath of minister specified in the fourth schedule to the Constitution. 116. Vacation of office of minister. The office of a minister shall become vacant, A, if the appointment of the holder of the office is revoked by the president, or B, if the holder resigns, becomes disqualified to be member of parliament, or 3, dies. 117. Responsibility of ministers. Ministers shall individually be accountable to the president for the administration of the ministries and collectively be responsible for any decision made by the cabinet. 118. Vote of censure. Parliament. 1. Parliament may, by resolution supported by more than half of all members of parliament, pass a vote of censure against a minister or any on any of the following grounds: A. Abuse of office or willful violation of the oath of allegiance or oath of the office. B. Misconduct or misbehavior. C. Physical or mental incapacity, namely, that he or she is incapable of performing the functions of his or her office by reason of physical or mental incapacity. D. Mismanagement or E. Incompetence. 2. Upon a vote of censure being passed against the minister, the president shall, unless the minister resigns his or her office, take appropriate action in the matter. 3. Proceedings for censure of a minister shall be initiated by a petition to the president through the speaker signed by not less than 1/3 of all members of parliament, giving notice that they are dissatisfied with the conduct or performance of the minister and intend to move a motion for a resolution of censure and setting out particulars of the grounds in support of the motion. 4. The president, upon receipt of the petition, cause a copy of it to be given to the minister in question. 5. The motion for the resolution of censure shall not be debated until the expiry of 30 days upon the petition after the petition was sent to the president. 6. A minister, in respect of whom a vote of censure is debated under clause 5 of this article, is entitled during the debate to be heard in his or her defense. 119. Attorney General. 1. There should be an Attorney General who shall be a cabinet minister appointed by President with the approval of Parliament. 2. A person shall not be qualified to be Attorney General unless he or she is qualified to practice as an advocate of High Court and has so practiced or gained the necessary experience for not less than 10 years. 3. The Attorney General shall have the principal legal advisor of the government. For the functions of the Attorney General shall include the following: to give legal advice and legal services to the government on any subject. B. To draw and peruse agreements, contracts, treaties, conventions, and documents by whatever name called to which the government is a party or in respect of which the government has an interest. C. To represent the government in courts or any other legal proceedings to which the government is a party. And D. To perform such other functions as may be assigned to him or her by the president or by law. 5. Subject to the provisions of this constitution, no agreement, contract, treaty, convention, or document by whatever name called to which the government is a party or in respect of which the government has an interest shall be concluded without legal advice from the Attorney General, except in cases and subject to such conditions as Parliament may by law prescribe. 6. Until Parliament makes the law referred to in clause 5 of this article, the Attorney General may, by statutory instrument, exempt any particular category of agreement or contract, none of the parties to which is a foreign government or its agency or an international organization from the application of that clause. Director of Public Prosecutions. 120. Director of Public Prosecutions. 1. There shall be a Director of Public Prosecutions appointed by the President on the recommendation of the Public Service Commission and with the approval of Parliament. 2. A person is not qualified to be appointed Director of Public Prosecutions unless he or she is qualified to be appointed a Judge of the High Court. 3. Functions of the Director of Public Prosecutions are the following. A. To direct the police to investigate any information of a criminal nature and to report to him or her expeditiously. B. To institute criminal proceedings against any person or authority in any court with contempt jurisdiction other than a court-martial. C. To take over and continue any criminal proceedings instituted by any other person or authority. D. To discontinue at any stage before judgment is delivered any criminal proceedings to which this article relates, instituted by himself or herself or any other person or authority, except that the Director of Public Prosecutions shall not discontinue any proceedings commenced by another person or authority except with the consent of the court. 4. The functions conferred on the Director of Public Prosecutions under Clause 3 of this Article A may, in the case of the functions under Clause 3A, B, and C of this article, be exercised by him or her in person or by officers authorized by him or her in accordance with general or specified instructions. And B, shall, in the case of the functions under paragraph D of that clause, be exercised by him or her exclusively. 5. In exercising his or her powers under this article, the Director of Public Prosecutions shall have regard to the public interest, the interest of the administration of justice, and the need to prevent abuse of legal process. 6. In the exercise of functions conferred on him or her by this article, the Director of Public Prosecutions shall not be subject to the direction or control of any person or authority. 7. The Director of Public Prosecutions shall have terms and conditions of service as those of a High Court judge. Prerogative of mercy. 121. Prerogative of mercy. 1. There shall be an advisory committee on the prerogative of mercy, which shall consist of A. The Attorney General, who shall be the chairperson, and B. 6 prominent citizens of Uganda appointed by the President. 2. A person shall not be qualified for appointment as member of committee if he or she is a member of Parliament, the Uganda Law Society, or a district council. 3. A member appointed under Clause 1B of this article shall serve for a period of 4 years and shall cease to be a member of Committee A if circumstances arise that would disqualify him or her from appointment, or A. B. If removed by the President for inability to perform the functions of his or her office arising from infirmity of body or mind, or for misbehavior, misconduct, or incompetence. 4. The President may, on the advice of Committee A, grant to any person convicted of an offense a pardon either free or subject to lawful conditions. B. Grant to a person a respite, either indefinite or for a specified period, from the execution of punishment imposed on him or her for an offense. C. Substitute a less severe form of punishment for a punishment imposed on a person for an offense. Or D. Remit the whole or part of a punishment imposed on a person, or of a penalty of forfeiture, otherwise due to government on account of any offense. 5. Where a person is sentenced to death for an offense, a written report of the case from the trial judge or judges, or a person presiding over the court or tribunal, together with such other information derived from the record of the case or elsewhere as may be necessary, shall be submitted to the advisory committee on the prerogative of mercy. 6. A reference in this article to the conviction or imposition of a punishment, sentence, or a forfeiture includes a conviction or an imposition of a punishment, penalty, service, of a forfeiture by a court-martial or other military tribunal, except a field court-martial. International relations. 122. Diplomatic representation. 1. The President may, with the approval of Parliament, appoint ambassadors and heads of diplomatic missions. 2. The President may receive envoys envoys accredited to Uganda. 123. Execution of treaties, conventions, and agreements. 1. The president or a person authorized by the president may make treaties, conventions, agreements, or other arrangements between Uganda and any other country, or between Uganda and any international organization or body in respect of any matter. 2. Parliament shall make laws to govern ratification of treaties, conventions, agreements, or other arrangements made under Clause 1 of this article. Declaration of state of war. 124. Declaration of state of war. 1. The President may, with the approval of Parliament, given by resolution supported by not less than 2/3 of all members of Parliament, declare that a state of war exists between Uganda and any other country. 2. Where it is impracticable to seek the approval of Parliament before declaration of a state of war, the President may declare a state of war without the approval, but shall seek the approval immediately after declaration, and in any case not less than 72 hours after the declaration. 3. Where the President makes the declaration of state of war under Clause 2 when Parliament is in recess, the Speaker shall immediately summon Parliament to an emergency session to sit within 72 hours after the declaration of a state of war. The President may, with the approval of Parliament given by resolution, revoke a declaration of state of war made under Clause 1 or 2 of this article. National Planning Authority. 125. National Planning Authority. There should be a National Planning Authority whose composition and functions shall be prescribed by Parliament. Chapter 8. The Judiciary. Administration of Justice. 126. Exercise of judicial power. 1. Judicial power is derived from the people and shall be exercised by courts established under the Constitution in the name of people and in conformity with law and with values, norms, aspirations of people. 2. In adjudicating cases of both a civil and a criminal nature, the courts shall, subject to the law, apply the following principles. A. Justice shall be done to all irrespective of their social or economic status. B. Justice shall not be delayed. C. Adequate compensation shall be awarded to victims of wrong. D. Reconciliation between parties shall be promoted, and E. Substantive justice shall be administered without undue regard to technicalities. 127. Participation of people in the administration of justice. Parliament shall make law providing for participation of people in the administration of justice by the courts. 128. Independence of the judiciary. 1. The exercise of judicial power. The courts shall be independent and shall not be subject to control or direction of any person or authority. 2. No person or authority shall interfere with courts or judicial officers in the exercise of their judicial functions. 3. All organs and agencies of state shall accord to the courts such assistance may be required to ensure the effectiveness of the courts. 4. A person exercising judicial power shall not be liable to any action or suit of any act or omission by that person in the exercise of judicial power. 5. The administrative expenses of the judiciary, including all salaries, allowances, gratuities, and pensions payable to or in respect of persons serving in the judiciary, shall be charged to the consolidated fund. 6. The judiciary shall be self-accounting and may deal directly with the ministry responsible for finance in relation to its finances. 7. The salary, allowances, privileges, retirement benefits, and other conditions of service of a judicial officer or other person exercising judicial power shall not be varied to his or her disadvantage. 8. The office of Chief Justice, Deputy Chief Justice, Principal Judge, a Justice of the Supreme Court, a Justice of Appeal, or a Judge of the High Court shall not be abolished when there is a substantive holder of that office. The courts of judicature. Oh my god, this word is very hard for me. 129. The courts of judicature. 1. The judicial power of Uganda shall be exercised by the court of judicature, which shall consist of A. The Supreme Court of Uganda, B. The Court of Appeal, C. The High Court of Uganda, and D. Such subordinate courts as Parliament may by law establish, including Kwandi Hills courts for marriage, divorce, inheritance of property, and guardianship as may be prescribed by Parliament. 2. The Supreme Court, the Court of Appeal, and High Court of Uganda shall be superior courts of record and shall have all powers of such a court. 3. Subject to the provisions of this Constitution, Parliament may make the provision for the judication and procedure of the courts. The Supreme Court of Uganda, 130. The Supreme Court of Uganda. The Supreme Court shall consist of A. The Chief Justice, and B. Such number of judges of the Supreme Court, not being less than 6 as Parliament may prescribe. 131. Composition of the Supreme Court. 1. The Supreme Court shall be duly constituted at any sitting if it consists of an even number not being less than 5 members of court. 2. When hearing appeals from decisions of the Court of Appeal sitting as a constitutional court, the Supreme Court shall consist of a full bench of all members of Supreme Court, and where any of them is not able to attend, the President shall for the purpose appoint an acting justice under Article 142(2) of this Constitution. 3. The Chief Justice shall preside at each sitting of the Supreme Court, and in the absence of the Chief Justice, the most senior member of the court as constituted shall preside. 132. Jurisdiction of the Supreme Court. 1. The Supreme Court shall be the final court of appeal. 2. An appeal shall lie to the Supreme Court from such decisions of the Court of Appeal as may be prescribed by law. 3. Any party aggravated by a decision of the Court of Appeal sitting as a constitutional court is entitled to appeal to the Supreme Court against the decision, and accordingly an appeal shall lie to the Supreme Court under Clause 2 of this article. 4. The Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so, and all other courts shall be bound to follow the decisions of the Supreme Court on questions of law. 133. Administrative functions of Chief Justice. 1. The Chief Justice A shall be the head of judiciary and shall be responsible for the administration and supervision of all courts in Uganda, and B. may ensure orders and directions to the courts necessary for the proper and efficient administration of justice. 2. Where the office of the Chief Justice is vacant, or where the Chief Justice is for any reason unable to perform the functions of his or her office, then until a person has been appointed to and has assumed the functions of that office, or until the Chief Justice has resumed the performance of those functions shall be performed by the Deputy Chief Justice. The Court of Appeal of Uganda. 134. Court of Appeal of Uganda. 1. The Court of Appeal of Uganda shall consist of A. The Deputy Chief Justice, and B. Such number of justices. These are justices, right? Justices of appeal not being less than 7 as Parliament may by law prescribe. 2. An appeal shall lie to the Court of Appeal from such decisions of the High Court as may be prescribed by law. 135. Composition of the Court of Appeal. 1. The Court of Appeal shall be duly constituted at any sitting if it consists of an even number not being less than 3 members of the court. 2. The Deputy Chief Justice shall preside at each sitting of the court, and in the absence of the Deputy Speaker, the Deputy Chief Justice, the most senior member of the court as constituted, shall preside. 3. The Chief Justice, in consultation with the Deputy Chief Justice, may create divisions of the Court of Appeal as the Chief Justice may consider necessary. A. Consisting of such numbers of justices of appeal as may be assigned to them by the Chief Justice. B. Sitting at such places in Uganda as the Chief Justice may, after consultation with the Attorney General, be statutory order determined. 136. Administrative functions of the Deputy Chief Justice. 1. Subject to the provisions of Article 133 of this Constitution, the Deputy Chief Justice shall A. Deputize for the Chief Justice as and when the need arises. B. Be the head of the Court of Appeal, and in that capacity assist the Chief Justice in the administration of that court. And C. Perform such other functions as may be delegated or assigned to him or her by the Chief Justice. 2. Where A. The office of the Deputy Chief Justice is vacant. B. The Deputy Chief Justice is acting as a Chief Justice. Or C. The Deputy Chief Justice, for any reason, unable to perform the functions of his or her office, then until a person has been appointed to and has assumed the functions of the office of the Deputy Chief Justice, those functions shall be performed by a Justice of the Supreme Court or a Justice of Appeal designated by the President after consultation with the Chief Justice or the Acting Chief Justice, as the case may be. Constitutional Court. 137. Questions as to the interpretation of the Constitution. 1. Any questions as to the interpretation of this Constitution shall be determined by the Court of Appeal sitting as the Constitutional Court. 2. When sitting as a Constitutional Court, the Court of Appeal shall consist of a bench of 5 members of that court. 3. A person who alleges that A. An act of Parliament or any other law or anything in or done under the authority of any law, or B. Any act or omission by any person or any authority is inconsistent with or in contravention of a provision of this Constitution, may petition the Constitutional Court for a declaration to that effect and for redress where appropriate. 4. Where upon determination of the petition under Clause 3 of this article, the Constitutional Court considers that there is need for redress in the addition to the declaration sought, the Constitutional Court may A. Grant an order of redress, or B. Refer the matter to High Court to investigate and determine the appropriate redress. Like that word matter was going to read mattress. I was going to say mattress instead of matter. See, my concentrating levels. But anyway, we'll try, right? We will try. We'll try to get it out. 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 I'll try to get it out. We'll try to get it out. Where are we? Where are we now? Where are we now? Where any question as to the interpretation of this constitution arises in any proceedings in a court of law other than a field court martial, the court shall, yo, what's up? You okay? Yeah, it's on. A may, if it is of the opinion that the question involves a substantial question of law, and B, shall, if any party to the proceedings requests it to do so, refer the question to the Constitutional Court for decision in accordance with Clause 1 of this article. 6. Where any question is referred to the Constitutional Court under Clause 5 of this article, the Constitutional Court shall give its decision on the question, and the court in which the question arises shall dispose of the case in accordance with that decision. 7. Upon a petition being made or a question being referred under this article, the Court of Appeal shall proceed to hear and determine the petition as soon as possible, and may, for the purpose, suspend any other matter pending before it. High Court of Uganda, 138. A minute. We will try to get it done. Yeah, low man. You need to know low. In Uganda, you need to know it, man. Because I was saying how these people treat you if you know nothing about laws, about if they get to know that you don't know anything, the way they can treat you. I was seeing it all over social media. Try to get it. Yeah? I'm already in low. My good. I'll do you later. You're going to cause a ruckus here. Ah. I can't lie to you, man. Okay. I was multitasking and it was giving me issues. I need to concentrate on one. The High Court of Uganda, 133. High Court of Uganda, 1. The High Court of Uganda shall consist of the principal judge and B, such number of judges of the High Court as may be prescribed by Parliament. 2. The High Court shall sit in such places as the Chief Justice may, in consultation with the principal judge, appoint, and in so doing the Chief Justice shall, as far as practicable, ensure that the High Court is accessible to all the people. 139. Jurisdiction of the High Court. 1. The High Court shall, subject to the provisions of this Constitution, have unlimited original jurisdiction in all matters and such appellate and other jurisdiction as may be conferred on it by this Constitution or any other law. 2. Subject to the provisions of this Constitution and any other law, the decisions of any court lower than the High Court shall be appellable to the High Court. 140. Hearing of election cases. 1. Where any question is before High Court for determination under Article 108 of this Constitution, the High Court shall proceed to hear and determine the question expeditiously and may for the purpose suspend any other matter pending before it. Yeah? To what? I don't know, man. I was also feeling it and I wasn't like, help me, and don't know the cable, that cable, see, knock it. Yeah? I have to begin with this. Where was I? Okay, 141. As administrative functions of the principal judge. 1. Subject to the provisions of Article 133 of this Constitution, the principal judge shall A. be the head of High Court and shall, in the capacity, assist the Chief Justice in administration of the High Court and subordinate courts, and B. perform such other functions as may be delegated or assigned to him or her by the Chief Justice. 2. Where A. the office of principal judge is vacant, or B. the principal judge is for any reason unable to perform the functions of his or her office, then until a person has been appointed to and has assumed the functions of that office, or until the principal judge has resumed those functions shall be performed by a judge of the High Court designated by the President after consultation with the Chief Justice. Appointments, qualifications, and tenure of office of judicial officers. 142. Appointment of judicial officers. 1. The Chief Justice, the Deputy Chief Justice, the Principal Judge, a Justice of Supreme Court, a Justice of Appeal, and a Judge of High Court shall be appointed by the President, acting on the advice of the Judicial Service Commission and with the approval of Parliament. 2. Where A. the office of a Justice of the Supreme Court or a Justice of Appeal or a Judge of High Court is vacant. B. a Justice of the Supreme Court or a Justice of Appeal or a Judge of the High Court is for any reason unable to perform the functions of his or her office, Or C, the justice advises the Judicial Service Commission that the state of business in the Supreme Court, Court of Appeal, or the High Court so requires, the President may, acting on the advice of the Judicial Service Commission, appoint a person qualified for appointment as Justice of the Supreme Court, or a Justice of Appeal, or a Judge of High Court to act as such as Justice or Judge, even though that person has attained the age prescribed for retirement in respect of that office. 3. A person appointed under Clause 2 of this article to act as the Justice of the Supreme Court, a Justice of Appeal, or a Judge of High Court shall continue to act for the period of the appointment, or if no period is specified, until the appointment is revoked by the President, acting on the advice of the Judicial Service Commission, whichever is the earlier. 143. Qualifications for appointment of judicial officers. 1. A person shall be qualified for appointment as A Chief Justice if he or she has served as a Justice of the Supreme Court of Uganda, or of a court having similar jurisdiction, or has practiced as an advocate for a period not less than 20 years before a court having unlimited jurisdiction in civil and criminal matters. B. Deputy Chief Justice or Principal Judge if he or she has served as a Justice of the Supreme Court, or a Justice of Appeal, or a Judge of High Court, or a Judge of similar jurisdiction to such a court, or has practiced an advocate for, or has practiced as an advocate for a period not less than 15 years before a court having unlimited jurisdiction in civil and criminal matters. C. A Justice of the Supreme Court if he or she has served as a Justice of Appeal, or a Judge of the High Court, or a court of similar jurisdiction to such a court, or has practiced as an advocate for a period not less than 15 years before a court having unlimited jurisdiction in civil and criminal matters. D. A Justice of Appeal if he or she has served as a Judge of the High Court, or a court having similar or higher jurisdiction, or has practiced as an advocate for a period not less than 10 years before a court having unlimited jurisdiction in civil and criminal matters, or is a distinguished jurist and an advocate of not less than 10 years standing. E. A Judge of High Court if he or she is or has been a judge of a court having unlimited jurisdiction in civil and criminal matters, or a court having jurisdiction in appeals from any such court, or has practiced as an advocate for a period not less than 10 years before a court having unlimited jurisdiction in civil and criminal matters. 2. Any period during which a person has practiced as a public officer holding an office for which qualification as an advocate is required shall be contained in the calculation of any period of practical practice required under Clause 1 of this article, even though that person does not have a practicing certificate. 144. Tenure of office of judicial officers. 1. A judicial officer may retire at any time after attaining the age of 60 years and shall vacate his or her office. A. In the case of the Chief Justice, the Deputy Chief Justice, a Justice of the Supreme Court, and a Justice of Appeal on attaining the age of 70 years, and B. In the case of the Principal Judge and the Judge of the High Court on attaining the age of 65 years, or in each case subject to the Article 128(7) this Constitution on attaining such other age as may be prescribed by Parliament by law, but a judicial officer may continue in office after attaining the age at which he or she is required by this clause to vacate office for a period not exceeding 3 months, necessary to enable him or her to complete any work pending before him or her. 2. A judicial officer may be removed from office only for a inability to perform the functions of his or her office arising from infirmity of body or mind. B, misbehavior or misconduct or incompetence, but only in accordance with the provisions of this article. 3, the president shall remove a judicial officer if the question of his or her removal has been referred to a tribunal appointed under clause 4 of this article, and the tribunal has recommended to the president that he or she ought to be removed from office or on any ground described in clause 2 of this article. 4, the question whether the removal of a judicial officer shall be investigated shall be referred to the president by either the Judicial Service Commission or the Cabinet, which with advice that the President shall appoint a tribunal, and the President shall then appoint a tribunal consisting of a, in the case of the Chief Justice, the Deputy Chief Justice, or the Principal Judge, 5 persons who are or have been justices of the Supreme Court or have been judges of a court having similar jurisdiction, or who are advocates of at least 20 years standing. B, in the case of a justice of Supreme Court or a justice of appeal, 3 persons who are or have been judges of the Supreme Court or who are or have been judges of a court of similar jurisdictions, or who are advocates of at least 15 years standing. Or C, in the case of a judge of high court, 3 persons who are or have held office as judges of a court having unlimited jurisdiction in civil and criminal matters, or a court having jurisdiction in appeals from such a court, or who are advocates of at least 10 years standing. B, if the question of removing a judicial officer is referred to as a tribunal under this article, the president shall suspend the judicial officer from performing the functions of his or her office. C, a suspension under clause 5 of this article shall cease to have effect if the tribunal advises the president that the judicial officer suspended shall not be removed. 7, further to the purposes of this article, judicial officer means the Chief Justice, the Deputy Chief Justice, the Principal Judge, a Justice of the Supreme Court, a Justice of Appeal, or a Judge of the High Court. 145, registrars. 1, there shall be in the judiciary the office of Chief Registrar and such number of registrars as Parliament may by law prescribe. 2, the Chief Registrar and a Registrar shall be appointed by President on the advice of the Judicial Service Commission. Judicial Service Commission 146. Judicial Service Commission. 1, there shall be a Judicial Service Commission. 2, the Judicial Service Commission shall, subject to clause 3 of this article, consist of the following persons who shall be appointed by the president with the approval of Parliament. 1, A, a chairperson and a deputy chairperson who shall be persons qualified to be appointed as justices of the Supreme Court other than the Chief Justice, the Deputy Chief Justice, and the Principal Judge. B, 1 person nominated by the Public Service Commission. C, 2 advocates of not less than 15 years standing nominated by the Uganda Law Society. D, 1 justice of the Supreme Court, 1 judge of the Supreme Court nominated by the President in consultation with the judges of the Supreme Court, the justices of appeal, and judges of high court. And E, 2 members of public who shall not be lawyers nominated by President. 3, the Attorney General shall be an ex-officio member of the Commission. 4, the Chief Justice and the Chief Justice, the Deputy Chief Justice, and Principal Judge shall not be appointed to be chairperson, deputy chairperson, or a member of the Judicial Service Commission. 5, a person is not qualified to be appointed a member of the Judicial Service Commission unless that person is of high moral character and proven integrity. 6, the office of chairperson shall be full-time. and a person shall not engage in private legal practice while holding that office. 7. Subject to the provisions of this article, a member of the Judicial Service Commission shall vacate his or her offices A. At the expiration of 4 years from the date of his or her appointment, but is eligible for reappointment for 1 more term. B. If he or she is elected or appointed to any office determined by Parliament to be likely to compromise the independence of the Judicial Service Commission, or C. On being removed by the President, but the President may only remove a member for inability to perform the functions of his or her office arising from infirmity of body or mind, or for misbehavior, misconduct, or incompetence. 8. There shall be a secretary to the Judicial Service Commission who shall be appointed by the President on the advice of the Public Service Commission. 107. Functions of the Judicial Service Commission. 1. The functions of the Judicial Service Commissions are A. To advise the President in the exercise of the President's power to appoint persons to hold or act in any office specified in Clause 3 of this article, which includes power to confirm appointments, to exercise disciplinary control over such persons, and to remove them from office. B. Subject to the provisions of this Constitution, to review and make recommendations on terms and conditions of service of judges and other judicial officers. C. To prepare and implement programs for the education of and for the dissemination of information to judicial officials and the public about law and the administration of justice. D. To receive and process people's recommendations and complaints concerning the judiciary and the administration of justice, and generally to act as a link between people and the judiciary. E. To advise the government on imposing administration of justice and if any other function prescribed by this Constitution or by Parliament. 2. In the performance of its functions, the Judicial Service Commission shall be independent and shall not be subject to the direction or control of any person or authority. 3. The offices referred to in Clause 1 and Clause 1A of this article are A. The office of the Chief Justice, the Deputy Chief Justice, the Principal Judge, a Justice of Supreme Court, a Justice of Appeal, a Judge of the High Court. B. And the office of the Chief Registrar and the Registrar. 148. Appointment of other judicial officers. Subject to the provision of this Constitution, the Judicial Service Commission may appoint persons to hold or act in any judicial office other than the offices specified in Article 147 of this Constitution and confirm appointments and exercise disciplinary control over persons holding or acting in such offices and remove such persons from office. Judicial oath. Every judicial official shall, before assuming the duties of his or her office, take and subscribe the oath of allegiance and the judicial oath specified in the first schedule to this Constitution. 105. Power to make laws relating the judiciary. 1. Subject to the provisions of this Constitution, Parliament may make laws providing for the structures, procedures, and functions of the judiciary. 2. Without prejudice to Clause 1 of this article, Parliament may make laws for regulating and facilitating the discharge by the President and the Judicial Service Commission of their functions under this chapter. Interpretation. In this chapter, under the context otherwise, judicial officer means a judge or any person who presides over a court or tribunal, however described. B. The chief registrar or a registrar of a court. C. Such other people holding any office connected with a court as may be prescribed by law. Chapter 9, Finance General. 152, Taxation 1. No tax shall be imposed except under the authority of an Act of Parliament. 2. Where a law enacted under Clause 1 of this article confers powers on any personal authority to waive or vary a tax imposed by that law, that person or authority shall report to Parliament periodically on the exercise of those powers and shall be determined by law. 3. Parliament shall make laws to establish tax tribunals for the purposes of settling tax disputes. 153. Consolidated Fund. 1. There shall be a consolidated fund into which shall be paid all revenues and other monies raised or received for the purposes of or on behalf of or in trust for the government. 2. The revenues or other monies referred to in Clause 1 of this article shall not include revenues or other monies A. that are payable by or under an Act of Parliament into some other fund established for a specified purpose, or B. There may, under an Act of Parliament, be retained by the Department of Government that received them for the purposes of defraying the expenses of that department. 154. Withdraw from the consolidated fund. 1. No money shall be taken from the consolidated fund except A. to meet expenditure charged on the fund by the Constitution or by an Act of Parliament, or B. where the issue of those monies has been authorized by the appropriate act, a supplementary appropriation act, or as provided under Clause 4 of this article. 2. No money shall be withdrawn from any public fund of Uganda other than the consolidated fund unless the issue of those monies has been authorized by law. 3. No monies shall be withdrawn from the consolidated fund unless the withdrawal has been approved by the Auditor General and in the manner prescribed by Parliament. 4. If the President is satisfied that the Appropriation Act in respect of any financial year will not or has not come into operation by the beginning of that financial year, the President may, subject to the provisions of this article, authorize the issue of monies from the consolidated fund account for the purposes of meeting expenditure necessary to carry on the services of the government until the expiration of 4 months from the beginning of that financial year or the coming into operation of the Appropriation Act, whichever is the early. 5. Any sum issued in any financial year from the consolidated fund account under Clause 4 of this article in respect of any service of government A shall not exceed the amount shown as required on account in respect of that service in the vote on account approved by Parliament by resolution for that financial year, and B shall be set off against that the amount provided in respect of that service in the Appropriation Act for the financial year when that law comes into operation. 155. Financial year estimates. 1. The President shall cause to be prepared and laid before Parliament in each financial year, but in any case not less than 15th day before the commencement of the financial year, estimates of revenues and expenditures of government for the next financial year. 2. The head of any self-accounting department, commission, or organization set up under this Constitution shall cause to be submitted to the President at least 2 months before the end of each financial year estimates of administrative and development expenditure and estimates of revenue of respective department, commission, or organization for the following year. 3. The estimates prepared under Clause 2 of this article shall be laid before Parliament by the President under Clause 1 of this article without revision, but with any recommendations that the government may have on them. 4. At any time before Parliament considers the estimates of revenues and expenditure laid before it by or on the authority of the President, an appropriate committee of Parliament may discuss and review the estimates and make appropriate recommendations to the Parliament. 5. Notwithstanding the provisions of Clause 1 of this article, the President may cause to be prepared and laid before Parliament a fiscal and monetary programs and plans for economic and social development covering periods exceeding 1 year. B. Estimates of revenue and expenditure covering periods exceeding 1 year. 6. Parliament may make laws for giving effect to the provisions of this article. 156. Appropriation Bill. Appropriation Bill 1. The heads of expenditure contained in the estimates other than expenditure charged on the consolidated fund by this Constitution or any other act of Parliament shall be included in a bill to be known as Appropriation Bill, which shall be introduced into Parliament to provide for the issue from the consolidated fund of the funds necessary to meet the expenditure and the appropriation of those sums for the purposes specified in the bill. 2. If in respect of any financial year it is found a. That the amount appropriated for any purpose under the Appropriation Act is insufficient, or that a need has arisen for expenditure for a purpose for which no amount has been appropriated by that act, or B. That any monies have been expended for any purpose in excess of the amount appropriated for that purposes, or for a purpose for which no amount has been appropriated by that act. A supplemental estimate showing the sums required or spent shall be laid down before Parliament, and in the case of excess expenditure within 4 months after the money is spent. 3. Where in respect of any financial year a supplemental estimate or supplemental estimates have been approved by Parliament in accordance with Clause 2 of this article, a supplementary appropriation bill shall be introduced into Parliament in the financial year next following that financial year to which the estimates relate, providing for the appropriation of the sums so approved for the purposes specified in those estimates. 157. Contingencies Fund. Parliament shall make a provision for the establishment of contingencies fund and shall make laws to regulate the operations of that fund. 158. Offices of the remuneration of which is charged on the consolidated fund. 1. Where any salary or allowance of holder or any where salary or allowance of the holder of any office charged on the consolidated fund, it shall not be altered to his or her disadvantage after he or she has been appointed to that office. Subject to the provision of this Constitution, Parliament shall prescribe the offices, the salaries, and allowances in respect of which are charged on the consolidated fund by this Constitution. 159. Power of government to borrow or lend. 1. Subject to the provisions of this Constitution, government may borrow from any source. 2. Government shall not borrow, grant, or raise a loan on behalf of itself or any other public institution, authority, or person except as authorized by or under an Act of Parliament. 3. An Act of Parliament made under Clause 2 of this article shall provide that the terms and conditions of the loan shall be laid before Parliament and shall not come into operation unless they have been approved by resolution of Parliament, and B. That any monies received in respect of that loan shall be paid into the consolidated fund and form part of that fund, or into some other public fund which is existing or is created for the purpose of the loan. 4. The President shall, at such times as Parliament may determine, cause to be presented to Parliament such information concerning any loan as necessary to show a the extent of the total indebtedness by way of principal and accumulated interest. B. The provision made for servicing or repayment of the loan and the utilization and performance of that loan. 5. Parliament may by resolution authorize the government to enter into an arrangement for the giving of a loan or a grant out of any public fund or public account. 6. An arrangement entered into under clause 5 of this article shall be laid before Parliament and shall not come into operation unless it has been approved by Parliament by resolution. 7. For the purposes of this article, the expression loan includes any money lent or given to or by the government on condition of return or repayment, and any other form of borrowing or lending in respect of which a money from the consolidated fund or any other public fund may be used for repayment or repayment, or B. Monies from any fund by whatever name called established for the purposes of payment or repayment, whether in whole or part, and whether directly or indirectly, may be used for payment or repayment. 8. Parliament may by law exempt any categories of loans from the provisions of clauses 2 and 3 of this article, subject to such conditions as Parliament may prescribe. 160. Public debt. The public debt of Uganda shall be charged on the consolidated fund and other public funds of Uganda. 2. For the purposes of this article, the public debt includes the interest on that debt, sinking fund payments in respect of that debt, and the costs, charges, and expenses incidental to the management of that debt. Central Bank of Uganda. 161. The Central Bank. 1. The Bank of Uganda shall be the Central Bank of Uganda and shall be the only authority to issue the currency of Uganda. 2. The authority of the central bank shall vest in a board which shall consist of governor, a deputy governor, and not more than 5 other members. 3. The governor, the deputy governor, and other members of the board shall A. be appointed by President with approval of Parliament. B. Hold office for a term of 5 years but shall be eligible for reappointment. 4. The office of governor and deputy governor shall be a public office, and the governor and the deputy governor shall respectively be chairperson and deputy chairperson of the board. 5. The governor, the deputy governor, or any other member of the board may be removed from office by the president only for inability to perform the functions of his or her office arising from infirmity of body or mind. B. Misbehavior or misconduct, or C. Incompetence. 162. Functions of the central bank. 1. The Bank of Uganda shall A. Promote and maintain the stability of value of the currency of Uganda. B. Regulate the currency system in the interest of the economic progress of Uganda. C. Encourage and promote economic development and the efficient utilization of resources of Uganda through effective and efficient operation of a banking and a credit system. And D. Do all such other things not inconsistent with this article as may be prescribed by law. 2. In performing its functions, the Bank of Uganda shall conform to this constitution but shall not be subject to the direction or control of any person or authority. 3. Subject to the provisions of this constitution, Parliament may make laws prescribing and regulating the functions of Bank of Uganda. Auditor General. 163. Auditor General. There shall be an Auditor General who shall be appointed by President with the approval of Parliament and whose office shall be a public office. 2. A person shall not be appointed Auditor General unless that person A. is a qualified accountant of not less than 15 years standing and is a person of high moral character and proven integrity. 3. The Auditor General shall A. audit and report on the public accounts of Uganda and of all public offices, including the courts, the central and the local government administrations, universities and public institutions of like nature, and any other public corporation or other bodies or organizations established by an act of parliament, and B, conduct financial and value for money audits in respect of any project involving public funds. 4. The Auditor General shall submit to Parliament annually a report of the accounts audited by him or her under Clause 3 of this article for the financial year immediately preceding. 5. Parliament shall, within 6 months after the submission of the report referred to in this clause 4 of this article, debate and consider the report and take appropriate action. 6. Subject to clause 7 of this article, in performing of his or her functions, the Auditor General shall not be under the direction or control of any person or authority. 7. The President may, acting in accordance with the advice of the Cabinet, require the Auditor General to audit the accounts of anybody or organization referred to in clause 3 of this article. 8. The salary and allowances payable to the Auditor General shall be charged on the consolidated fund. 9. The accounts of the Office of the Public General shall be audited and reported upon by an auditor appointed by Parliament. 10. The Auditor General may be removed from office by the President only for A. Inability to perform the functions of his or her office arising from infirmity of body and or mind, B. Misbehavior, misconduct, or C. Incompetence. 164. Accountability. 1. The permanent secretary or the accounting officer in charge of a ministry or department shall be accountable to Parliament for the funds in that ministry or department. 2. Any person holding a political or public office who directs or concurs in the use of public funds contrary to existing instructions shall be accountable for any loss arising from that use and shall be required to make good the loss even if he or she has ceased to hold that office. 3. Parliament shall monitor all expenditure of public funds. Chapter 10. The Public Service Commission. 165. Public Service Commission. 1. There shall be a Public Service Commission. 2. The commission shall consist of a chairperson, a deputy chairperson, and 7 other members appointed by the President with the approval of Parliament. 3. A person is not qualified to be appointed a member of the commission unless he or she is of high moral character and proven integrity. 4. A person holding any of the following offices shall relinquish his or her position in that office on appointment as a member of the commission. A member of Parliament. B. A member of a local government council. C. A member of executive of a political party or political organization. Or D. A public officer. 5. A member of the commission shall hold office for a term of 4 years but is eligible for reappointment, except that of the first appointed under this constitution, 4 shall be appointed to hold office for 3 years, which shall be specified in the instruments of appointment. 6. The emoluments of the members of the commission shall be prescribed by Parliament and shall be charged on the consolidated fund. 7. In the absence of both the chairperson and the deputy chairperson, the President may designate one of the members to act as chairperson. 8. A member of the commission may be removed from office by the President for only A. Inability to perform the function of his or her office arising from infirmity of body or mind. B. Misbehavior or misconduct. Or C. Incompetence. 106. Functions of the Public Service Commission. 1. Except otherwise provided in this Constitution, the functions of the Public Service Commission include A. To advise the President in performing his or her functions under Article 172 of this Constitution. B. To appoint, promote, and exercise disciplinary control over persons holding office in the public service of Uganda as provided in the Article 172 of this Constitution. C. To review the terms and conditions of service, standing orders, training, and qualifications of public officers and matters connected with personnel, management, and development of public service, and make recommendations on them to the government. D. To guide and coordinate district service commissions. E. To hear and determine grievances from persons appointed by district service commissions. And F. To perform such other functions as may be prescribed by this commission, constitution, or any other law. 2. In the exercise of its functions, the Public Service Commission shall be independent and shall not be subject to the direction or control of any person or authority, except that it shall take into account government policy relating to the public service. 3. The Commission shall make a report to Parliament in respect of each year on the performance of its functions. 4. Parliament shall by law empower the Public Service Commission to make regulations for the effective and efficient performance of its functions under this Constitution or in other law. Education Service Commission 167. Education Service Commission. There shall be an Education Service Commission 2. The commission shall consist of a chairperson and 6 other members appointed by the President with the approval of Parliament. 3. The President shall appoint not more than 2 members of the commission as deputy chairpersons of the commission. 4. A person is not qualified to be a member of the commission unless he or she is of high moral character and proven integrity and has substantial experience in the field of education. 5. A person holding any of the following offices shall relinquish his or her position in that office on appointment as a member of the commission. A member of parliament. B, a member of local government council. C, a member of the executive of a political party or a political organization. D, a member of any board or other authority responsible for the management of any school or college. Or E, a public officer. 6. A member of the Education Service Commission shall hold office for 4 years, but is eligible for reappointment except of the first members appointed under this Constitution. 3 shall be appointed to hold office for 3 years, for which shall be specified in the instruments of appointment. 7. The emoluments of members of the Commission shall be prescribed by Parliament and shall be charged on the consolidated fund. 8. In the absence of the chairperson and the deputy chairperson, the President may designate one of the members to act as chairperson. 9. A member of the Commission may be removed from office by the President only for A. Inability to perform the functions of his or her office arising from infirmity of body or mind. B. Misbehavior or misconduct. Or C. Incompetence. 168. Functions of the Education Service Commission. 1. Subject to the provisions of this Constitution, the Education Service Commission shall A. Advise the President in performing in relation to the education service his or her functions under Article 172 of this Constitution. B. Have power to appoint persons to hold or act in any office in the education service, including the power to confirm such appointments, to exercise disciplinary control over those persons, and to remove them from office. C. Review the terms and conditions of service, standing orders, training, and qualifications of public officers in the education service and matters connected with their government, management, and welfare, and make recommendations on them to the government. D. Perform such other functions as may be prescribed by the Constitution or in other law. 2. In the exercise of its functions, the Commission shall be independent and shall not be subject to the direction or control of any person or authority, except that it shall take into account government policy relating to education. 3. The Commission may be by writing delegate any of its functions to a district service commission or any other authority or officer. 4. The Commission shall make a report to Parliament in respect of each year on the performance of its functions. 5. Subject to the provisions of this article, Parliament shall by law regulate the functions of the Commission and prescribe the categories of public officers to constitute the Education Service, Health Service Commission. There shall be a Health Service Commission. The commission shall consist of a chairperson and 6 other members, at least 3 of whom shall be persons who have substantial experience in health science, all of whom shall be appointed by the President with the approval of Parliament. 3. The President shall appoint 1 member of the Commission as deputy chairperson of the Commission. 4. A person is not qualified to be a member of the Commission unless he or she is of high moral character and proven integrity. 5. A person holding any of the following offices shall relinquish his or her office on appointment as a member of the Commission. A member of Parliament. B. A member of a local council, a local government council. C. A member of the executive of a political party or political organization. D. A member of any board or other authority responsible for the management of any government hospital or similar government establishment or public officer. 6. A member of the Commission shall hold office for 4 years but is eligible for reappointment except that of the first members appointed under this Constitution. There shall be appointment to hold office for 3 years, which shall be specified in the instruments of appointment. 7. The emolument of members of the Commission shall be prescribed by Parliament and shall be charged on the consolidated fund. 8. In the absence of both the chairperson and the deputy chairperson, the President may designate one of the members to act as chairperson. A member of the Commission may be removed from office by President only for A, inability to perform the functions of his or her office arising from infirmity of body or mind. B. Misbehavior, misconduct, or incompetence. C. 170. Functions of Health Service Commission. 1. Subject to the provisions of this Constitution, the Health Service Commission shall A. Advise the President in performing in relation to the health service his or her functions under Article 172 of this Constitution. B. Have power to appoint persons to hold or act in any office in the health service, including the power to confirm such appointments, to exercise disciplinary control over those persons and to remove them from office. C. Review the terms and conditions of service, standing orders, training, and qualifications of members of the health service and matters connected with the management and welfare and make recommendations on them to the government. They perform such other functions as may be prescribed by the Constitution or any other law. 2. In the exercise of its functions, the Commission shall be independent and shall not be subject to the direction or control of any person or authority, except that it shall take into account government policy relating to health. 3. The Commission may by writing delegate any of its functions to a district service commission or any other authority or officer. The Commission shall make 4. The Commission shall make a report to Parliament in respect of each year on the performance of its functions. 5. Subject to the provisions of this article, Parliament shall by law regulate the functions of the Commission and prescribe the categories of public officers to constitute the health service. General. 171. Establishments of offices. I need to get it done. I don't want to get distracted right now when I don't need to get distracted right now when I'm about to get done with this. Okay, I was somewhere and was causing some violence. I like to go there and I also want to be involved. Well, these guys come back. I'm back. Anyway, it's very hard for me to get people to watch me, but Chris is always around. Anyway, establishment of offices. Subject to the provision of this Constitution and any act of Parliament, the President may, after consultation with appropriate service commission, establish offices in the public service of the government of Uganda. 172. Appointment of public officers. 1. Subject to the provisions of this Constitution, the President may, acting in accordance with the advice of the Public Service Commission, the Education Service Commission, or the Health Service Commission, as the case may be, appoint persons to hold or act in any office in the public service of Uganda of the rank of head of department or above, other than those referred to in Article 200 of this Constitution, including confirmation of appointments, the exercise of disciplinary control over such persons, and their removal from office. B. The Public Service Commission, the Education Service Commission, or the Health Service Commission, as the case may be, may appoint persons to hold or act in any office in the public service of Uganda other than those referred in the paragraph A of this clause and in the Article 200 of this Constitution, including the confirmation of their appointments and the exercise of disciplinary control over such persons and their removal from office. 2. Except with the consent of the President, no person shall be appointed under this article to act in any office on the personal staff of the President. 3. Subject to the provision of this Constitution, the President may delegate any of his or her powers under this article by directions in writing to any service commission or to any other authority or public officer as may be prescribed by Parliament, and may in like manner revoke the delegation. 173. Protection of public officers. A public officer shall not be victimized or discriminated against for having performed his or her duties faithfully in accordance with this Constitution, or be dismissed or removed from office, or reduced in rank or otherwise punished without just cause. 174. Permanent secretaries. 1. Subject to the provisions of this Constitution, a ministry or department of government of Uganda shall be under the supervision of a permanent secretary, whose office shall be a public office. 2. A permanent secretary shall be appointed by President, acting in accordance with advice of the Public Service Commission. 3. The functions of a permanent secretary under this article include: A. Organization and operation of department or ministry. B. Tendering advice to the responsible minister in respect of the business of the department or ministry. 3. Implementation of the policies of government of Uganda. D. Subject to Article 164 of this Constitution, responsibility for the proper expenditure of public funds by or in connection with department or ministry. 177. 175. In this interpretation, in this chapter, unless the context otherwise requires, A. Public officer means any person holding or acting in an office in the public service. B. Public service. Public service means service in any civil capacity of the government, the emoluments for which are payable directly from the consolidated fund or directly out of monies provided by Parliament. Chapter 11. Local government. Principles and structures of local government. 176. Local government system. 1. The government of local government in Uganda shall be based on the district as a unit under which there shall be such lower governments and administrative units as Parliament may by law provide. 2. The following principles shall apply to the local government system. A. The system shall be such as to ensure the functions, powers, and responsibilities are devolved and transferred from the government to local government units in a coordinated manner. B. Decentralized shall be a principle applying to all levels of Decentralization shall be a principle applying to all levels of local government, and in particular from higher to lower government units, to ensure people's participation and democratic control in decision making. C. The system shall be such as to ensure the full realization of democratic governance at all local government levels. D. There shall be establishment for each local government unit a sound financial base with reliable sources of revenue. E. Appropriate measures shall be taken to enable local government units to plan, initiate, and execute policies in respect of all matters affecting the people within their jurisdiction. F. Persons in the service of local government shall be employed by the local governments, and G. The local government shall oversee the performance of persons employed by the government to provide services in their areas and to monitor the provision of government services or the implementation of projects in their areas. 3. The system of local government shall be based on democratically elected councils on the basis of universal adult suffrage in accordance with Article 181(4) of the Constitution. 177. Districts of Uganda. 1. Subject to the provisions of this Constitution, for the purposes of local government, Uganda shall be divided into districts referred to in Article P52 of this Constitution. The districts referred to in Clause 1 of this Constitution shall be taken to have been divided into local government units which existed immediately before the coming into force of this Constitution. 178. Cooperation among districts. 1. 2 or more districts shall be free to cooperate in the areas of culture and development as set out in the 5th schedule to this Constitution, and may, for that purpose, form and support councils, trust funds, or secretariats, subject to the following. A. Such cooperation shall conform to the democratic principles enshrined in this Constitution. B. The councils, trust funds, or secretariats so formed shall not have power to levy taxes, but Parliament may make provision enabling them to raise funds in addition to funds made available to them by the cooperating districts. C. The terms and conditions of the cooperation shall be embodied in a character signed by the consenting districts and deposited with the Speaker of Parliament. And D. The councils, trust funds, or secretariats formed under this article shall have power to make rules, regulations, and bylaws in relation to the functions assigned to them, except that such rules, regulations, and bylaws shall not be inconsistent with the provisions of this Constitution or any existing law, and shall not be effective unless ratified by district councils of the cooperating districts. 2. The councils, trust funds, or secretariats formed under this article shall be bodies corporate with powers to sue and be sued. 3. Subject to Clause 1 of this article and to the provisions of this Constitution, the districts of Buganda, as specified in the 1st schedule to this Constitution, shall be deemed to have agreed to cooperate on the coming into force of this Constitution. 4. Any district may withdraw from cooperation under this article if a resolution is passed by district council of the district in favor of withdrawal, supported by 2/3 of all members of the council, and the resolution is supported by resolution of parliament. 179. Boundaries of local government units. 1. Subject to the provisions of this constitution, parliament may alter boundaries of districts and create new districts. 2. Any measure to alter the boundary of a district or to create a new district shall be supported by a majority of all the members of parliament. 3. Parliament shall by law empower district councils to alter the boundaries of lower local government units and to create new local government units within their districts. 4. Any measure for the alteration of the boundaries of all the creation of districts or administrative units shall be based on the necessity for effective administration and the need to bring services closer to the people, and it may take into account the means of communication, geographical features, density of population, economic viability, and the wishes of the people concerned. 180. Local government councils. 1. A local government shall be based on a council which shall be the highest political authority within its area of jurisdiction and which shall have legislative and executive powers to be exercised in accordance with the Constitution. 2. Parliament shall by law prescribe the composition, qualifications, functions, and electoral procedures in respect of local government councils, except that a. The person elected as chairperson of a local government shall be a member of the council. B. 1/3 of the membership of each local government council shall be reserved for women. C. Any law enacted by virtue of this article shall provide for affirmative action for all the marginalized groups referred to in Article 32 of this Constitution, and D. Parliament shall exercise similar powers of review as stipulated in Article 78(2) of this Constitution in relation to paragraph B and C of this Constitution. 3. A person shall not be a member of a local government council unless that person is a citizen of Uganda. 181. Elections of local government councils. 1. A district shall be divided by the Electoral Commission into electorate areas which shall be demarcated in such a way that the number of inhabitants in the electoral areas are as nearly as possible equal to the number of inhabitants in an electoral area may be greater or less than other electoral areas in order to take account of means of communication, geographical features, and density of population. The demarcation of electoral areas shall ensure that a sub-county, a town council, or an equivalent part of a municipality is represented at district council by at least one person. 4. All local government councils shall be elected every 4 years. 5. Elections of all local government councils shall take place at least 60 days before the expiry of the term of the existing council, but shall not coincide with presidential or parliamentary elections. 182. Revocation of mandate. 1. Subject to clause 2 of this article, the mandate of an elected member of a local government council may be revoked by the electorate. 2. Parliament shall by law prescribe the grounds on which and the manner in which the electorate may revoke the mandate of an elected member of a local government council. 183. District chairperson. 1. There shall be a district chairperson who shall A. Be the political head of the district, and B. Be elected by universal adult suffrage through a separate ballot. 2. A person is not qualified to be elected district chairperson unless he or she is A. qualified to be elected as a member of parliament, B. at least 30 years and not more than 75 years of age, and C. a person ordinarily resident in the district. 3. The district chairperson shall A. preside at meetings of the executive committee of the district. B. monitor the general administration of the district. 3. coordinate the activities of urban councils and councils of the lower local administrative units in the district. D. coordinate and monitor government functions as between the district and the government. And E. perform such other functions as parliament may prescribe. 4. In the performance of the functions under Clause 3 of this article, the chairperson shall be subject to the rules, decisions, and recommendations of the district council and be answerable to the council. 184. Speaker of a district council. 1. Each district council shall have a speaker elected by the district council from among its members, but a person shall only be taken to have been elected if the votes cast in his or her favor are more than 50% of all members of the council. 2. The person of the council shall, in relation to the council, perform similar functions to those of the Speaker of Parliament. 185. Removal of a district chairperson and speaker. 1. The district chairperson or the speaker of a district council may be removed from office by the council by resolution supported by the votes of not less than 2/3 of all members of council on any of the following grounds: A. abuse of office. B. misconduct or misbehavior. Or C. such physical or mental incapacity as would render him or her incapable of performing the duties of his or her office. 2. Parliament shall prescribe any other grounds, and the procedure for the removal of a district chairperson and or the speaker of a council are under this article. 186. District Executive Committee. There shall be an executive committee. Feel like I need now to. Oh, my brain. Feel like I've read a lot. Oh, I've read a lot, man. Oh, God. I need to be back. I read a lot and I need to be back. I just need to be back. I feel like the rest will be for tomorrow. Will tomorrow ever be there? Will tomorrow ever be there? Will there ever be tomorrow? Will I want to push this to tomorrow? Will tomorrow ever be there? I'm just asking, will there ever be tomorrow? Let me be back. I think we'll begin from there. Where was that? But let me just finish this chapter. Did I? I think I was. Okay, District Executive Committee. There shall be an executive committee for each district council which shall perform the executive function of the council. 2. An executive committee shall consist of A. The district chairperson, B. The vice chairperson, and such number of secretaries as the council may decide. 3. The vice chairperson shall be a person nominated by the district chairperson from among members of the council and approved by 2/3 of all members of the council. The secretaries. 4. The secretaries shall be nominated by the chairperson from among members of the council and approved by a majority of all members of the council. 5. The vice chairperson shall deputize for the chairperson and shall perform such other of such functions as may be assigned to him or her by the commission chairperson. 6. If the district chairperson dies, resigns, or is removed from office, the chairperson shall assume the office of the chairperson until the elections of a new district chairperson, but the election shall be held within 6 months after the occurrence of the event. 7. A secretary shall have responsibility for such functions of the district council, and the district chairperson may from time to time assign to him or her. 8. A district chairperson shall appoint standing and other committees necessary for the efficient performance of its functions. The following. 9. The following shall apply with respect to the composition of the committees of a district council. I think we will begin from here. Among the chairpersons and members of the committees shall be elected. I think we will begin from here. How many are there? I can't go with them. I need now to engage. Now time for me to engage. Hey, now I'm here to engage. I am here to engage. Where are you? I am here to engage. Now I am here to engage. Now I am here to engage. Hey, oh my God. I had not looked at the time. Oh my God. Like, I had not looked at the time. I'm supposed to be out of here by now. But let's make it. Let's make it. Oh my God, we can't do it. We can't do it. We can't do it. We can't. We came late, so we have to. Something here I need. Something here we need to. I don't know. I think I have to be going. I don't know when I'll be back here. Okay. Okay, so I have to be going. Where are you? Where am I going after here? Where am I going after here? That's the question that I ask myself every time when I'm done streaming. I ask myself, now what? Where are you going? Every time I ask myself that question, after here, where am I going? Where? Got me. Where should I be going? Where should I be going after here? Where should I be going after here? That's the question that I need to be asking myself. Where am I going after here? Yeah. Where should I be going after here? Where should I be going after here? Where can I go after here? Where can I go? Where can I go after here? Every time I bring myself here. But my life needs to be free. I need to know more than here. I need to know more than here. I need to know more than here. Yeah. I need to know more than here. That's what I need to know, like more than here. I need to know more than here. I need to know more than here. More than here is what I need to know. My life is, I need to know my life more than here. I need to know my life more than here. Oh my, it's late. Wait. Oh, time is. I thought it was. I thought it was 9. I thought it was 9. Oh my god. Not 9. Okay, still here. If Chris is on. So who is on? 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 Who's on? Who's on? Who is 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 One song. One song. One song. God, man. I can't do this anymore, God. One song. One song. One song. One song. Oh God, I can't do this anymore, God. Oh, what can I do, man? Good man, doing like follow everything. I do good man. Good morning, good morning. can't put food on the table, God. And all of the day, God. Yeah, God. Feel good, doing something. 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 Something Eric, I'm leaving, man. Oh. You know, like there's a tendency when I come at this place, there's no electricity and Wi-Fi. Yeah, yes I did. You didn't tell me at 9. I couldn't wait up to 9. And I stay in Mukono, it's very far, it drains me. drink water. Just don't know what to do anymore, God. I just don't know what to do anymore, God. I just don't know what to do anymore. I just don't know what to do anymore. Like out of what to do anymore. Like what out of to do anymore. Like what to do anymore. Like what to do anymore. Like what to do anymore. What to do anymore. Like 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 what you do anymore. Like what you do. Like what you do. Like what you do anymore. Like what you do. 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 Like what you do, like what you do, like what you do, like what you do, what you do, like 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 what you do anymore, like what you do, like what you do.